Welcome back to Kivumbi2017 here on KTN News. Thank you for staying with us. Now, it was 12 hours of the 6 judges of the Supreme Court that sat and made that decision on the 1st of September to make their detailed judgment. And one of the block, thing that you can take from that is that they quashed the President Uhuru Kenyatta's re-election because that the National Returning Officer, Chebukati, did not verify the results before declaring the winner. We'll come back to that. Let's now take a look at some of the key pointers in that election, in that detailed judgment by the 4 judges. It says that no election is perfect and that the law realizes that, the law recognizes that. That is one of the things that is said. The other thing is that it is difficult to categorize the violations of the law as minor inadvertent errors. That is according to the 4 judges. In their view, IBC behaved as though the provisions of the Constitution did not exist. Another thing they said is that elections are not only about numbers, that to arrive at mathematical solution as taught in school, that one has to prove that the process indeed gives rise to the stated solution. The other thing they said is that illegalities and irregularities were so substantial that no court in this republic could ignore them. The other thing they said, no criminal culpability on the IEBC, the chairman of the IEBC, Wafula Chebukati, or any other member of the IEBC. The other thing, another key pointer from that judgment, manually transmitted forms arrived. That is what the judges were wondering, why manually transmitted forms arrived faster than the electronic ones. The IBC also declared that Uhuru Kenyatta, the IBC declared Uhuru Kenyatta as winner based solely on forms 34B, which according to the judges, some of them had questions over them. No criminal culpability, we've already talked about that, on Chebukati or any member of the IEBC. There was also a point that there was no evidence of misconduct on the part of President Uhuru Kenyatta. Just some of the pointers to come out of this. But the key factor here, the big decision or the big pointer to take out from this is that they quashed the election of Uhuru Kenyatta because the National Returning Officer, Wafula Chebukati, did not verify the results before declaring the winner. That is what we were talking about very heatedly just before the break. And Brian is wondering what verifying means. But what I understand is that it is the fact that despite whatever was in the Form 34B had to be corroborated. Yes. With whatever was in the electronically transmitted. Don't you think so?
I think so, and this is the point. Mm-hmm. I've heard the judgment, I've read the judgment, and from my understanding, the main query from the judgment was the key-in data, the one we were seeing on TV, versus the form, versus the scanned form. 3 things. The key-in data, you should ignore it because instead of typing 34, I can type 43. That can be a genuine mistake on keying in. But the scanned form and the real form, when I send you M-Pesa Ben, you receive a message, I receive a message, we can check that out. When this form is this, Form 34, you go to Form 34C and check, does it conform with Form 34's B's? Then you note this Form 34's B's has a problem. You go back to Form 34's A's. Then to Form 34A's, most people have agents also who got the forms. It's good to tell me that from my agent, they told me I had 100 votes. Why is this in the Form 34B? It's saying 80. Then you go back to the ballot box of that station and count. Are they 80? Are they 100? That's the way of verifying. You cannot verify a form with a form. You will always go. The reason there were all those systems is so that you can always go back until you follow the trail until the end. The end was the ballot cast on the ballot box. That was the end. So you could have looked at the discrepancies, go back. That's what you call verification. From what I've heard from the judgment, even the judges themselves did not verify the report of their own registrar.
Ben, the opening words qualifying what a proper elections is it should be simple. Simple, in fact, is the opening word. If something is so simple, it can also be verified. And when this case began, I remember, and it was like a whole Kenyan court, the judges demanded, after the application by the opposition, by the petitioner, that these documents are needed so that we can have a look at them, including now the digital documents, those who are not availed. If you say you want to verify, as simple as it should be, and you cannot provide the documentation you have been requested to provide so that it can be verified by the parties before the judges. Now, how do you then come around and say the judges should have verified? When were they supposed to do that? This is a presidential petition. It's not like we have 6 months for these other petitions. It's 14 days. You have to do everything within those timelines. Then you are saying, even though you should have all 290 documents from every constituency and then verify. It is not possible, Ben. What you should do is show that we have good faith. The documents you are requesting, here they are. And now let the other side verify and then inform the court what you have found. In failure to do that, definitely the judges, and they have not said that they looked at each document. Even Justice Ndungu cannot genuinely say that she looked at 290 40,800 polling papers. That is not possible.
That's the problem. Joki said there were specific forms that the petitioner, that the petitioner pinpointed specifically, number one. Number two, whatever he has said on verification, that's why I'm wondering, the bench differed. Joki said, and Ojuang, that whatever order was ordered, it was adhered to.
You say they differed. How do you choose to believe?
Why do you choose? That's the biggest problem.
Yeah,
that's why I'm saying we should review this judgment. Because if the bench can differ, the one says that it was not adhered to, another one said that it was adhered to, and he even went further.
What's your input on this?
In fact, in his judgment, he has 70 pages of those forms annexed. So that's the biggest problem we have.
What's your input on this issue of verifying?
Now, Ben, it would be a tragedy if you've got a bench which always rules in the same direction. They're supposed to take a vote. Everybody's supposed to come with a divergent view, a divergent opinion, so that you are able to verify. But the elephant in the room, and that's the question that we are tiptoeing around here, there was an application made by NASA that there should be open access to the servers. And the order was granted, and IBC was requested to open up the servers. One wonders why IBC declined to do that. Even as we speak up to this stage, they've not been able to open the servers to assist in that process of verifying the details. Now, when a court gives you specific orders, like the Supreme Court did, that let's open the server, and they appointed their own experts, professors, as well as practitioners. And there were people, Jubilee had representatives as well as NASA. One would have expected that if IIBC conducted a free, fair, and credible election, that would have been a very good opportunity for them to embarrass NASA and say we were able to carry this election in a manner that is very transparent. So the elephant in the room is, why have they ignored those orders up to date? Now,
we need to move on. We need to move on.
They were given 10 minutes to respond, only 10 minutes.
Let me just clarify that matter.
Yes.
Now, if you speak to judges, and Mr. Nyaribo is a lawyer, when you disobey court orders, then the judges are left with no option but to come up with an adverse inference that there's something you are actually hiding. That's number one. Number two, for Mr. Mbogwa says that we should have actually gone back to the ballot boxes. One wonders why the Jubilee lawyers, or even IBC, or even President Kenyatta's lawyers, did not make an application to get the ballot boxes.
All right,
but they should have had it as a prayer. They should have had it as a prayer.
Wait a minute.
Should do their work.
Wait a minute. The electoral, this is one of the findings. The Electoral Commission failed to grant access to two critical areas of their servers. Its logs, which would have proved or disproved the petitioner's claim of hacking in its servers that contain forms 34 and 34B. And the next pointer is that IBC's disobedience of the court's order left the judges with no option but to accept Mr. Raila Odinga's claim that either the Commission's IT system was infiltrated and data doctored, or IBC's officials themselves interfered with the data.
Can I answer that?
Yes.
It's very simple. When you are given an order and you fail to fulfill everything, you are given a chance to explain why you did not do A, B, C, D. IBC gave some
disobeying the highest court in the land.
It's not disobeying, Ben. When I tell you go bring me a rocket here from the US in the next 24 hours, of course there are some obstacles. There's something. The reason why I'm angry with that is because that was a tangential thing. It was outside the main petition, number one. It was brought in the petition, ordered when the petition was going on, not in the original petition, and that was the basis of the ruling, the main basis of this ruling. That's where I'm going away from,
in fact, technically,
from that judgment. So IBC and the Jubilee were not given time to respond to that report. Were they given time, there could have been better explanation to that.
The benefit of IBC not revealing what is in the servers is this, that you see that the majority judgment says that we were unable to find the fingerprints or footprints?
Yeah, footprints.
Yes, and you can see that if actually they opened, probably we could have found the footprints. So well, it is negative, but probably it covers IABC that you are not able to pinpoint.
But one thing,
you see, there was rumor, and it was a credible rumor, that the chairman's password was used a couple of times. Now, the judges cannot go up and say, this password was used by Mr. Ishmael Nyaribo, who works for the IBC.
But one thing,
but if they opened it, they would have actually found the person who did it.
But one thing, IBC gave the logs. The NASA brigade come with that thing that, no, we want to access it ourselves. You know, the order was not expressed. I'm an IT guy. I know what logs look like. You can download them and give it to them. The court order was not expressed. In fact, the court did not say open up the servers. It gave specific orders.
All right.
Give us the logs.
Let's talk about one final thing before we wind up the show, and that is the IBC, which will be conducting a fresh election in the next 34 days. And let's talk about NASA and their demands of reforms, no election. Now, another finding in this judgment, another highlight, Mr. Odinga claimed that various electoral offences were committed by IBC officials, but no evidence was placed before the court to prove the allegation. The judges, however, noted a systemic institutional problem, but could not point specific fingerprints of individuals who may have played a role. In the next pointer, the judges were unable to impute any criminal culpability to IBC, Mr. Chebukati, commissioners or any members of the IBC. So what does this mean, Dismas? Because NASA says no reforms at the IBC, no election. No. This ruling, the detailed judgment does not place any criminal culpability on any of the IBC officers.
You raised the three fundamental issues. Number one, the Supreme Court indicated this election was not held in a manner that respects the Constitution, and a number of electoral offences were committed. And it's important for us to recognize the fact that this was not a criminal proceeding. The person who's supposed to engage in criminal matters is Keriako Tobiko. Now, Keriako Tobiko has been told in global terms that there were illegalities and there were irregularities. And as the Supreme Court, we suspect there is mischief here. We've got sufficient information and evidence to point us in that particular direction. And my understanding, and I've spoken to a number of lawyers, the thinking is that if the Supreme Court indicates in a blanket statement that a number of commissioners are guilty or staff members are guilty, then the lower courts which are going to try these criminal offenses are going to be restrained. They're going to be limited. So essentially what the Supreme Court has done, it's given the lower courts a blank check. It's given Keriako Tobiko a blank check. Keriako Tobiko has been now invited to go to IBC and start fishing out on his own motion those irregularities and illegalities. It would be absurd for the Supreme Court to start prosecuting people for those electoral offences. That's not within their space. For them, they're supposed to be looking at the global picture. And that's why one would have expected that now for Mr. Chebukati and his team, they would quickly identify what are these irregularities, what are these illegalities, and then do a quick special audit in a bipartisan manner, sort out that mess. And you know, one would have expected, and at this stage probably people don't agree with what Mr. Orengo said, that IBC now is as good as a crime scene, that it's supposed to be fenced off so that Keriako Tobiko goes in and starts fishing out for that information.
All right. Do you agree with that, Brian? What is your take on the fact that this particular petition did not find any criminal culpability on the IBC officials?
I think when I told you that when the judges were reading their judgment on all the illegalities, they found none from their own judgment. They read all the prayers.
They said there was no evidence.
Just, of course, when there's no evidence, you find none. Because they used evidence to confirm, number one. So they found nothing illegal. They say it was systematic. In this sense, you know, where failure to put a stamp is not an illegality. DPP cannot charge you for not putting a stamp on a form, for not appending your signature on a form. That is administrative. That is how IBC set up. Those are regulations, not necessarily the law governing the election. And that's where the president is mad, saying you nullified an election based on irregularities. Those are small administrative things. And right now, for IBC and their staffer, it's their own internal thing. It's up to IBC to determine whether they will start disciplinary action on the employees. I don't know based on what, because the Supreme Court give them a clean bill of health.
Yeah,
let's hear the final thoughts.
I just don't want to be petty, but the Supreme Court found that the elections were held so irregular and so illegally, but found that they could not apportion criminality, and that should be very clear. It's a question of they did not find that a staff at IBC committed a certain crime. But in terms of whether elections were held illegally or with illegalities, it is clear in the judgment they were conducted with illegalities and irregularities. Lastly, Ben, on my part, what I think NASA and Jubilee should do, they should have no problem to go to the elections, even on the 26th. Why? The Supreme Court has reconfirmed that if you do not conduct elections in accordance with the law, we are able to repeat and ready to repeat the same thing. So I don't think even the NASA fraternity should really be so worried. Yes, a few changes in terms of express mistakes where they have been done, it's okay. But they should go to the elections, and if it's not done correctly, we go back to the Supreme Court.
30 seconds. 30 seconds. What I can challenge people and whoever is watching is this. The ruling is there. It is headed section of irregularities, section of illegality. Just pinpoint one thing that IBC did that was illegal.
All right.
Just pinpoint one.
It's all there in the judgment.
No, just pinpoint one.
It is in the Supreme Court.
You cannot even mention one.
The Supreme Court.
You cannot even mention
the judgment.
Because they did not put it.
This must 30 seconds begin right now.
So that we make progress as a nation,
yes,
what we must do is obey the Supreme Court's order, open up that server, have a forensic audit, identify the challenges, sort them out so that we have a free, fair, and credible election. And I disagree with Mr. Nyaribo. We should not go to another election full of irregularities and illegalities so that, again, we go back to the Supreme Court and then they annul the election. It becomes like a pendulum, left, right, left, right. Chebukati should do the right thing. Do a special audit, do a forensic audit, open up the servers, come up with a system which is very predictable, so that the only unpredictable thing is the outcome.
All right.
Outside that, we'll be wasting time.
Thank you so much, gentlemen. It's a conversation that we can have for 2-3 hours. Dismas Mokua, political risk analyst, Jubilee strategist Brian Bogu, and lawyer Ishmael Nyaribo. Thank you so much for joining me tonight and sharing your perspective. That's why we leave it. The conversation continues after that 12-hour detailed judgment by the 6 judges of the highest court in the land. President Uhuru Kenyatta says the Supreme Court has lowered the threshold for annulling or nullifying presidential election in this country. Raila Odinga says it is time to end electoral inequalities. Chief Justice David Maraga, CJ, says he would do it all over again if he is under the same case. So we leave it. It is back to the drawing board. Elections on the 26th of October. I'm Ben Kitili. That's why we leave it. At the top of the hour, I'll be back with Katie and Frank.